Good morning, Your Honor. Edward Drugas on behalf of Ashley Fix.
Ashley Ian Fix.
All right. Your Honor, we've gone through the pre-sentence report. The recommendation is something my client wants to address today. The only correction I have to the face of the pre-sentence report is the attorney should be listed as myself rather than public.
Okay. Ma'am, anything you want to tell the court before I sentence?
I was wondering if I could be placed on probation. Since
You want to be placed on probation?
yeah, since I did a month in the Wayne County last month. I'd rather be on probation than incarcerated.
Right out of the gate, the defendant makes a straightforward request. Probation instead of jail. On the surface, that sounds reasonable. After all, she points out that she already spent time in custody and would rather remain in the community than serve additional incarceration. But courtroom decisions are rarely based on what someone prefers. They're based on history, compliance, and credibility. And that's exactly where this case is heading. Judge Simpson is about to examine whether the defendant has actually demonstrated the kind of behavior that would justify a probationary sentence. What makes this moment important is that sentencing hearings often become a test of trust. The court wants to know, if given another chance, will this person follow through, or will the same problems continue? That's the tension hanging over this entire proceeding. The defense is asking for leniency, but the court record may tell a very different story. And here's the question for everyone watching. If someone has already spent time in custody, should that automatically help their chances of receiving probation, or should the court focus entirely on their pattern of behavior? Keep that thought in mind, because the answers coming up are going to shape everything that follows.
Your Honor, Teresa Clare on behalf of probation.
Yes.
Ms. Fix was ordered to probation to complete the pre-sentence interview appointment. It took some effort to get that done initially because it was done quite some time ago, and then Ms. Fix has numerous times failed to appear to this court for sentencing. While she has been out on bench warrant status, she's also picked up other cases, one being an OWI out of the 15th District Court, which is holding her in custody. Not to mention, it was brought to my attention, she now has a couple other cases out of
Romulus,
which are bench warranted now because she has failed to appear, I believe, because she was not here.
it was a show cause. I don't think a warrant issue.
I went to court.
Oh, a show cause.
Yeah.
So she is, Your Honor, scheduled
Oh,
for show cause matters because she failed to appear, because she was in custody here for those Romulus cases. Probation's concern with Ms. Fix is that she does come before this court and indicates that she wants to do things, but she never follows through with any of it. So probation has concerns that if Ms. Fix were to be released on this case, she's not going to do it, and she's not going to contact probation. I know that, and this court knows how I operate. I attempted to reach Ms. Fix multiple times to try to even get her to get in here to get sentenced, because originally I believe my recommendation was to have a probationary sentence. However, it's getting her here, and if she doesn't come to court, she's not going to report to probation.
Well, and the cold hard reality is that May and June she didn't appear, but she just, the simplest of things to complete your pre-sentence interview, she didn't do.
This is where Judge Simpson begins laying out the foundation for his decision, and it's a damaging picture for the defense. Notice that the judge isn't focusing on a single mistake. He's focusing on repetition. The pre-sentence interview is one of the most basic requirements in the sentencing process. It's not an optional task. It's one of the first steps the court expects a defendant to complete. What really stands out here is the judge's emphasis on multiple bench warrants and repeated failures to appear. In sentencing, courts often distinguish between someone who made one bad decision and someone who repeatedly ignored court orders. Judge Simpson is clearly signaling that he's seeing the latter. Every missed appearance chips away at credibility. Every missed obligation makes probation look less like an opportunity for rehabilitation and more like a risk. From the court's perspective, probation only works when the individual actually reports, communicates, and follows instructions. The judge is essentially asking a practical question. If the defendant wouldn't complete the simplest court-directed tasks, why should the court believe future probation conditions will be followed? That's a difficult hurdle for the defense to overcome, and the courtroom momentum is beginning to shift sharply against the request for probation.
Had to issue a bench warrant in her cases, in this case, 4 times before we can get you here.
I promise I'll do it.
You're not a good candidate for probation. I mean, I couldn't even get you to interview with probation initially. You didn't even follow the court's instruction to do that. And then had the bench warrant you didn't appear, had to basically make it an in-person hearing, which I don't specifically recall why, but that typically means there's an issue going on with getting the person there. So, and I'm not sure, in January of this year, you were brought into custody somehow. So even after I'd issued 2 bench warrants, one that I recalled, you did that. And on the recommendation initially on April 24, 2024 was for a probationary sentence, but that was in April of 2024. You didn't appear. I issued a bench warrant, and then we don't see you until January. The magistrate, I'm not sure why, but granted you a PR in January, on January 16th. On January 29th, you were supposed to appear before me, and you didn't show up. You came back again into custody for whatever reason in June, and the magistrate, I don't know why, gave you a PR because you said you'd appear. And that was in 2025. And on the date he gave you, you didn't appear. That's where we are. You don't do what you say you're going to do.
That may be the most important sentence of this entire hearing. Judge Simpson has boiled the case down to one central issue: reliability. Courts hear promises every day. Defendants promise they'll report. They promise they'll complete programs. They promise they'll appear for hearings. But judges ultimately evaluate actions, not intentions. What we're seeing here is frustration built over time. The judge walks through the timeline, points out missed appearances, references opportunities that were already given, and then arrives at a blunt conclusion. The problem isn't what the defendant says. The problem is that the record doesn't match the promises. This is why sentencing hearings often become less about the original offense and more about conduct afterward. Judges want evidence that someone can successfully function under supervision. If the court sees repeated non-compliance, probation starts looking less like a solution and more like a delay before a future violation hearing. At this stage, the defense is running out of room. The judge appears unconvinced that another chance will produce a different result. And when a judge reaches that conclusion, the possibility of jail time rises dramatically.
And the reality is, when I've seen these in the past, what will actually end up happening is we put you on probation, and then ultimately I'm imposing the jail time because you haven't done anything. Anything else?
Can I be placed on the tether? Should be asked tether.
Your Honor, the only thing I can express on her behalf is that she does have remorse for missing those dates.
All of them?
Yeah.
And other than that, I discussed with her what her options may be on taking.
My mom, I love my mom, so I have transportation.
She just addressed that she had stable housing through her mother. So that's
Sentence of the court, $125 statutory fee, 93 days in jail, credit 20. The balance, the defendant is to serve the balance. Thank you.
Thank you.
Any Rhodes?
Teresa Clare on behalf of probation, Your Honor. Mr. Rhodes is scheduled before the court today for a violation of probation hearing. Probation would like to correct the balance owed to the court is $1,055, with the last payment being made to the court on May 8, 2024. Mr. Rhodes has failed to complete the terms ordered by the court in that he did not complete IOP treatment. He failed to provide proof of his AA meeting attendance, failed to attend the victim's impact panel, failed to report to probation as directed. He also failed to appear at 2 prior VOP hearings before this court where bench warrants were issued. In addition to that, Your Honor, Mr. Rhodes has new pending criminal matters. One out of the 34th District Court for domestic violence. Alleged date of offense is May 11th of 2022. That is on bench warrant status.
The second case now brings a completely different defendant before Judge Simpson. But listen carefully, because some of the same themes are already emerging. Probation isn't merely about avoiding trouble. It's about actively completing court-ordered requirements. And according to probation, there are multiple areas where those obligations were not completed. The list being read into the record is extensive. Treatment issues, reporting issues, attendance issues, missed hearings, and additional pending criminal matters. None of those allegations automatically determine the outcome, but together they create a picture that probation clearly believes is significant. That's why their recommendation carries weight. What's especially notable is that probation isn't talking about one isolated violation. They're describing a pattern of non-compliance while the defendant was already under court supervision. When courts impose probation, they're effectively extending trust. When violations accumulate, judges often start questioning whether that trust has been justified. For viewers watching this unfold, here's an interesting question. Should a judge focus primarily on the probation violations themselves, or should personal circumstances and hardships carry equal weight during sentencing? That debate is about to become central to this hearing as the defense presents its side of the story.
He has 2 cases out of the 14A2 District Court, one being a domestic violence, the other being an attempted R&O. Alleged date of offenses, first being August 4th of 22, the other being November 3rd of 2022. He is scheduled for pretrials in both of those matters. He has another matter out of the 34th District Court for an alleged larceny under 200. That alleged date of offense is November 12th of 2023. He's on bench warrant status in that case. He also has a pending felony, a larceny in a building, alleged date of offense of June 27, 2025. He is scheduled for a PCC in that matter on July 10th of 2025. It appears, Your Honor, Mr. Rhodes has continued to pick up criminal cases while on bench warrant status in this case and being in violation of the probation that was ordered by this court. Given all of that, probation is recommending that the court order Mr. Rhodes to serve 93 days in jail with credit for 16 days that he served to date, that he served the balance, that he complete the in-jail on-farm program, waive remaining terms, accepting his financial obligations, and discharging him from probation with them.
Ms. Berman.
Your Honor, I am asking that you sentence Mr. Rhodes to the 16 days serves and close out this case. I did have an opportunity yesterday to speak with Mr. Rhodes for quite some time. I think what his issues really come down to is his finances. He explained to me that he and his family have been homeless all of last year and are just now getting back to a better spot. They were staying at the Red Roof Inn for some time, and then they stayed at shelter for some time. This is all while they had, at this time, they have 3 kids under 3. His partner just had their newest baby in January. And at the time during last year, she was obviously pregnant with 2 children. So they were dealing with some serious financial issues. Mr. Rhodes says he did not have even a phone or a car to get anywhere. He did say that he was enrolled in the MRT program, which he believed was being used, I suppose, in place of his IOP.
Now the defense begins presenting context, and this is where sentencing hearings become more complicated than simple rule following. The attorney isn't denying that problems occurred. Instead, she's trying to explain why they occurred. Homelessness, financial instability, lack of transportation, employment struggles, and the responsibility of caring for multiple young children all become part of the conversation. These details matter because judges are often asked to balance accountability with reality. The defense is essentially arguing that the violations weren't driven by defiance, but by circumstances that made compliance extraordinarily difficult. That's a very different argument than claiming nothing went wrong. At the same time, courts face a difficult challenge. Hardship can explain behavior, but it doesn't automatically erase probation requirements. Judges still have to determine whether someone complied with the orders they were given. What makes this hearing compelling is that both sides are presenting arguments grounded in facts. Probation points to missed obligations. The defense points to severe life instability. Judge Simpson now has to decide which factor deserves greater weight. That's the kind of balancing act that often determines whether someone receives another opportunity or faces immediate consequences.
So he did complete some of the MRT program, but he did not complete it as it does require money to stay in it. He did just do a week. I think he was picked up on the warrant and did pay bond to get out. He said during that time, just a week really affected his partner and their living situation because he could not work. He is enrolled in a job program through the Friend of the Court, so he is working now. He also says he did attend some AA meetings, but because of his situation, he wasn't able to continue to those. I do know that the larceny cases, he is being represented by the public defender's office, and he said there is an offer to reduce that felony case down to a misdemeanor. He's asking that the court take all this into consideration and the struggles that he and his family have been going through. But again, he is in stable housing now and is working.
The case ending in 1357, which is a show cause hearing, I'm going to adjourn that to September 10th, 2025 at 9 a.m. On this other matter, sir, is there anything else you want to tell me other than what your counsel's indicated?
Yes, Your Honor. That's what she said is exactly correct. It was a hard time, and I admit to the violation. I'm trying to get everything situated. I can make a payment today, and on the 12th, I just have to get rent paid before the 15th, and then I can continue to make payments every month until I can get the balance dismissed. Lowered down.
All these new cases, not doing it that way. Sentence of the court, 93 days in jail, credit 16 that he served. Defendant is to serve the balance. He's to report to the Washington County Jail by 6 p.m. today. If he fails to report, a bench warrant with no bond will issue. He is while in jail to complete the Dawn Farm in jail program. I will waive all other remaining terms except his financial obligations, discharge him from probation without improvement. Thank you.
Thank you.
And with that, Judge Simpson reaches his decision. Despite hearing about the defendant's financial struggles, housing instability, family responsibilities, and efforts to improve his situation, the court ultimately imposes a 93-day jail sentence with credit for time already served. The defendant must serve the remaining balance, report to jail by 6:00 p.m. that day, and faces a no-bond bench warrant if he fails to appear. The judge also orders participation in the Dawn Farm program while incarcerated, waives the remaining probation terms except for financial obligations, and discharges him from probation afterward. In practical terms, the court is choosing a custodial consequence rather than continuing a supervision model that it no longer appears confident will succeed. Looking back at both hearings featured in this segment, a common theme emerges: credibility and compliance. Judge Simpson repeatedly focused on whether defendants followed through on court orders, appeared when required, and demonstrated reliability over time. When those factors broke down, requests for leniency became much harder to justify. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.